Hello, dear friends and subscribers. Welcome again. Today, for our next podcast, I have invited the Professor of Information, Media, and Business Law at the University of Munster, Institute for Information, Telecommunication, and Media Law, Dr. Thomas Hoeren from Germany. Professor Thomas is a participant in the Central Asian Legal Research Fellowship Program of the Tashkent State University of Law, and Professor visited Uzbekistan with his family in last summer. Hello, dear Professor. Nice to see you here today on the podcast, and greetings from Uzbekistan to you.
Yeah, it's a pleasure to see you. I'm happy and honored to be invited for the interview.
Thank you. Thank you very much for agreeing. And Professor, we know that today we are going to speak about the cyber law and its jurisdiction, the jurisdiction of the cyber law. And also it's known as the internet law or information technology law, which encompasses the legal issues which is related to the use of the internet, computers, and technology. And jurisdiction is the context of cyber law, which is a crucial aspect. And as all we know, it determines which laws and regulations apply to online activities. And it can be quite complex in the global context, I think. And today we can see digitalization in every sphere, such as a cyber crime jurisdiction, data privacy, e-commerce, and contract law, and e-government, digital intellectual property law, fintech, social media law, digital rights, and so on. And the need for the cybersecurity is increasing day after day. And the first question will be, dear Professor Thomas, which is about cyber law. In what matter did cyber law evolve, creeping into our lives imperceptibly? And how are matters of jurisdiction addressed within the realm of cyberspace?
my feeling is that most civilized countries have made their homework in the area of internet law. So they have drafted beautiful legislations, they have clear court decisions for their state territory, but the system will not work in an international conflict, because we still have the major problems of private international law and international jurisdiction. So, for instance, how can you enforce a US case in Russia or China? So the Russian courts will not accept a US decision on the territory of Russia. That leaves a mosaic of strange gaps and interferences, because the differences of national legislation is still astonishing. So I feel that the execution of national orders will become the real big threat for the future.
Mm-hmm. Okay, thank you, Doctor, for the detailed answer. And as I mentioned before, we can see globalization of e-commerce, and it's becoming an essential need in our lives. I want to ask from you, what are the fundamental principles behind the electronic commerce and electronic contracts, and what are the legal considerations involved? And how can consumer rights be safeguarded in the realm of electronic commerce? And what are the mechanisms are in place to address disputes stemming from e-commerce transactions?
I can only speak for Europe, because your question is, of course, really broad. I can give a lecture for students. This will last 5 hours. But take Germany and the European Union. We have discovered that the general principles of contract law can be applied in the internet. So we have offer and acceptance. We have a kind of consideration. The rules on errors and mistakes can be applied. So if somebody makes a mistake, sending a wrong error to another person, the classical concept of error will be applicable. So that sounds good, but the problem still remains for consumers. So we have integrated in Europe a whole framework of several directions and directives, meaning that we have integrated a right to refusal and cancel every internet contract within a certain period. That's very good. So the consumer can change his mind and say, oh, I made really a mistake. I want to cancel the contract. Another thing which we did in Europe is to integrate the idea of transparency. So the seller should be very clear in the internet what he wants to offer. He should say the real price, the real, prohibit misleading advertisement, and that's very important. But again, as I said in the other questions, the problem still exists, that we have a certain strange seller sitting in Ukraine or Uruguay, and he is selling really, really nasty goods and products. So how can you enforce the rights of consumers in that international transaction? That seems to be very, very complicated, and that remains one of the biggest targets we have in Europe. Other problems is, of course, a problem with banks. How can you pay in the internet? It's complicated because how can you give your money, transact your money via internet? So can you use a credit card, which is risky? Can you transfer blockchain money? That means it leads to a lot of problems with blockchain money and cyber money. So there are still a lot of tasks to do. The other problems, I can tell you, they are existing in other industries. We have one big problem with medical treatment. Is it allowed that a doctor gives you advice, consult a client, a sick person via internet? That seems to be a very modern approach, but how can you guarantee that the message of the doctor is transmitted in a correct way, so that there is not a misunderstanding of the doctor's opinion? That remains a problem, and to a certain degree, it still is prohibited in Germany.
That's interesting, Professor. Thank you for your answer. And my next question will be about intellectual property, which has a status like traditional properties, and we have to protect them from unlawful privatization. And how intellectual property is protected in the cyber environment? And please tell us the issues of copyright infringement in the cyber environment.
Well, we had a lot of problems 10 years ago because a lot of, especially young people, use the internet for copying and sending illegal copies to their friends, and companies build up illegal services for giving access to illegal music and film files. That has had to be reduced, and that has been done by inventing heavy sanctions. If you get caught, if you get trapped with illegal copies, you get a high punishment in Germany and other European states. So that leads to a decrease of illegal copying. So the young people are using YouTube or Spotify, so there's no need to make illegal copies. And another idea, which I like very much, is the idea to use the technical chances in the internet for protecting music and files. So we call it digital rights management. So you take a digital content and you build up a kind of anti-copying device, so that is not technically possible to make illegal copies. And that's another important trend we face in intellectual property.
Blocking from screenshots and screen recordings.
Yeah, exactly. And that's the future, and it's highly done in Europe by big film companies and music companies. So the young people are not interested anymore in making illegal copies.
Thank you. And one additional question regarding digital intellectual property objects. And have you encountered disputes related to digital trademarks and domain names during your professional experience?
Well, I have worked as a Court of Appeal judge for 15 years. So I've seen a lot of cases, and especially cases on digital rights management tools. Because the music industry and film industry sometimes put too restrictive measures on the digital content. So they stopped the whole access to digital content, so that even a legal the user could not use the content. And that's the reason why we said in court, digital content can be protected by technical tools and can be blocked and so on, but only insofar as it is necessary for protecting copyright. So you cannot make too harsh restriction, technical restriction on a certain digital content. And that has been decided by my court several times. It has been later on decided by the Supreme Court, and we have even a famous decision of the European Court of Justice, the same famous Nintendo case, where the court has said exactly the same. Don't make too harsh restriction from a technical point is not allowed.
Mm-hmm. What about trademarks in the digital environment and the domain name disputes? Have you studied how it's going in Europe, in European countries?
So tell you another story. I've not only worked as a Court of Appeal judge, mm-hmm. but I have been an arbitrator in the WIPO mm-hmm. and the European Arbitration Court in the area of domain name disputes. And I'm a total fan of arbitration. Mm. I think that is really working, because you can imagine if you are disputing a domain name case in front of courts, you need to wait for a long time. It takes for sometimes 6-7 years, and you have to wait for the decision of the court. Yeah. So we need a more flexible and quicker tool, that is arbitration. And that's done by the WIPO as well as the European Court. And my feeling is that it is especially important for protecting against these domain name hijackers, which are situated in China, especially in China, because we still have strange guys in China who reserve a domain with a trademark in it and say, sorry, I have made a reservation for your trademark as part of a domain, but I can give you the domain if you pay me $10,000. Mm. And then you can sue in front of an arbitration court. You only have to pay $500, $600, $700, and within 2 weeks, 3 weeks, you have your domain which you want. Mm. So that's very easy and very sufficient.
Mm-hmm. So it's a way for getting domain names from China.
Yeah, especially from China. Because, as I said in the beginning, we have the problem of international jurisdiction. If somebody is coming from China, how can you sue in China to enforce a trademark against a domain? It's very complicated, very expensive. You don't have any idea what's happening in China. So you need another tool, as another solution.
Mm-hmm. Thank you. Thank you for sharing your experience as a judge and as an arbitrator. That was interesting. And next, my question will be about the social media law and its legal protection. How is social media legally regulated within the framework of cyber law, and what are the legal considerations regarding internet advertising and marketing in this context?
Well, we have a twofold system of protection within social media. We have, on the one hand, the idea of unfair competition law. It applies, for instance, in Germany to influencers. I don't like it, influencers. Mm. They are very nasty. And if they are too harsh. So that means they are pushing their opinion too harshly on the internet. Then we can protect against influencing. And the courts have done it and have said influencers should be clear in saying we got money from a company. So it has to be a transparent the system that we all know who is paying an influencer. So that's unfair competition law. In Germany is 100 years old and it's very, very easily enforced by courts. The main problem I see is another one. There is the power of social media platforms. That is now in Brussels a really big topic to use antitrust law, competition law, and then to build up new liability systems for fighting against Apple, Facebook, and the others. Because in social media, you can write everything what you want, and lawyers always are in fear, for instance, of hate speech, nasty remarks which some crazy types write in social media like Facebook and saying, my neighbor is a son of a bitch, and he is really annoying other people and frightening them. We need a kind of protection against the power of powerful platforms like Meta and the others. And that will be done by European regulations. We call them the EU Act as Digital Services Act, Digital Media Act, that are brand new, long statutory tools to fight against Meta and the others.
So you have special laws and codes on media law.
Yeah, we have special codes for media law, and we have even more special codes for social media. Because the fear the European Commission has is a fear that the big players in that area are Apple, Amazon, Meta, and Google, and we need to correct these big players in Europe, not only to apply unfair competition laws on a national level, but to have separate regulations for these big social media players like Meta and the others. The European Commission just made 4 important acts on regulating social media platforms, like the Digital Media Act, as an act which controls abusive powers, an antitrust law, pan-European antitrust law for the fight against Apple and the others. We have the Digital Services Act, which regulates the liability of Meta and the others on a European level, and even integrates a system of balancing the rights of users of this platform versus the rights of people writing on the platform. So there are very good regulations which needs to be implemented on the national level, because the courts and the national regulators need to be aware of what is happening in Brussels. So a lot of things to do in Europe.
Yeah, that's so interesting. Thank you. And today, like traditional crimes, we meet cyber crimes everywhere. And all cyber crimes on the internet similar to traditional crimes. And in what ways do they differ from traditional and digital crimes? And what characterizes traditional cybercrime? And what are the latest developments in the field of cybercrime? How do cyber attacks manifest in the digital landscape? Is there a process for reporting incidents of cyber fraud and identify the theft?
Well, that is a twofold question. We have made in Europe a system which leads to a new cybercrime system. So we have made new regulations for the protection against cybercrime in criminal law. So we changed the criminal laws throughout Europe for better fight against cybercrime. That has been made good, but we had a problem again with the international jurisdiction. Who is gets an information if a Russian or Chinese hacker tries to integrate in a system in Europe? So we made a new system for building up a European agency who gets all the information and how the information is going on till the final system operator gets really the effective information and knows what to do. There's a whole structure for getting a protection of European business against cybercrime. Because the biggest threat in the moment is international cybersecurity. We have very bad systems in Germany. Most companies are not very well equipped for the fight against hackers. So that led to a situation, for instance, that my university and the neighbor university got hacked by hackers from China. So we need to have a good system for getting a quick information on threats and getting a high punishment of these hackers.
Mm-hmm. Thank you. And your opinion is very interesting for us because it's very important. And could you share, please, Professor, prognosis for prospects of cyber law? What are the benefits and dangers of artificial intelligence for humanity? And how is artificial intelligence regulated? And are there national or international documents for using artificial intelligence today?
I'm very proud to say that Europe is now developing the first regulation on AI law in the world. So that's the first time Europe is quicker than the United States. The European Commission has said we need to have a new regulation on that matter, and that led to new system of classification of each AI system. So each AI system has to be classified if it is high risk system, if it's a middle risk system, or is a no risk system. If it's a high risk system, some systems are totally prohibited, like for instance, social scoring made by AI. That is a big threat. As well as forbidden control of the eye for transportation. That's all prohibited. In the middle section, like ChatGPT is classified as middle risk. You have to make a very transparent system, and have to explain everything which is integrated in the AI system, so that a normal person can understand what is going on with, for instance, ChatGPT. So if you have no risk, you're free to do what you want. So it's as well a kind of system for funding startup companies who want to build up a new AI system. That's what I like, but it's still in discussion at the European Parliament level. So, but in the next months, we might have the first worldwide AI regulation. And I would be proud to tell you more.
After enactment of this law, I think.
Yeah.
We will discuss that.
Next year in September, I will be with you, and I hope to tell you more what was the final result.
How it's working in Germany, artificial intelligence regulation, what is regulating, and how it's serving people to protect their digital rights and humanity. Okay, Professor Thomas, we thank you enough for your engaging and informative presence on this podcast today. And your deep knowledge and eloquent explanations have truly illuminated the interact world of cyber law and jurisdiction for our listeners, I think. And your dedication to educating and empowering the next generation of legal professionals is commendable, and we are fortunate to have had the opportunity to learn from you today. Your passion for this field is evident and inspiring. And as we conclude today's podcast, we eagerly anticipate your return for future episodes. As you give a promise, next year in September, we will discuss with you the artificial intelligence law. And your contributions are invaluable, and we look forward to more thought-provoking discussions and insights. Thank you, Professor Thomas, for your time, expertise, and the warmth you have brought to this conversation. And we appreciate your dedication to the legal community and the broader knowledge sharing space. Thank you.
Thank you.
Thank you very much. And dear subscribers, see you in the next episodes of our podcast. Bye. Thank you.
Thank you.